Today's moderator, meaning the least knowledgeable by far of all the people on the panel today. And I wanted to welcome you all to NAGDCA and welcome you to the 4.3 session. I'm compelled to give you information with respect to what you need for continuing education credits of various types. This is all that I know about that, however. So for those of you who need the information, please do read the slide. I otherwise wasn't educated on this. But I wanted to welcome you all here today. Before we begin going into the scintillating material, which will keep you gripped on the edge of your seat, white-knuckled, as we run through this ride of IRS audit information, I just wanted to say that we would love to have today be very, very interactive. We have somewhat of a choice with how we present these things. The choice can be either we give you overwhelming amounts of information in a slide, which is difficult to read and difficult to take away, or we really get to have a lot of stories told, a lot of illustrative examples, and a lot of interactions and your specific questions answered by the people who have been very formative in creating, forming, implementing the regulations that impact all of our plans. And so we chose the latter course. So we're hoping to have a good structure with the slides we have today, but to have the predominant portion of this be discussive. So if you wouldn't mind, please do interrupt us, raise your hand, ask questions throughout the course of today's discussion and presentation. And if you have anything that you'd like to pass up in terms of notes to the rest as well, you can please send it to the gentleman in the back, and they can also bring them up to us, and we can make sure that we have those addressed. So with that said, I'll give some introductions to today's panelists, and then we'll begin if there aren't any comments or questions from the folks in the room. For example, if you think, wait a minute, I was supposed to be in another session, isn't this how to scuba dive? I can address any of those questions now before we start off. No divers. Okay, great.
Get the makeup of the audience.
Get the makeup of the audience?
Yeah. I'm just curious about, is there higher ed, K through 12? How many are higher ed? How many are K through 12? Not many. Okay, then you must be state organizations that are looking to put in 403Bs. Okay.
All right, and then there are many others who are not raising their hands, so they're the divers. All right. Now we have water, so we'll be able to talk for more than 20 minutes. Fantastic. So I'll just go ahead and begin introducing the panelists as they go to my right, your left, and we're going to go over here. So we have to my right the famous Bob Architect, who currently is, and correct me if this guy right here. If I get anything wrong here, Bob, we were talking earlier about the first time I spoke to him in person, he corrected me. So I'll set a precedent here and hopefully make an error in his biography. But Bob's VP of Compliance, currently at VALIC, and from 1979 to 2009 was Senior Tax Law Specialist with the Employee Plans Division of the IRS. Since 1978, his specialty has been 403B plans. He's also served as a captain in the U.S. Army and holds a JD from Brooklyn Law School and an LLM from NYU. Did I make any mistakes?
Not yet.
Not yet. All right, we're on course. To his right, we have Ed Salyers. And Ed is a CPA and was a Senior Employee Plan Specialist with the Tax Exempt and Governmental Entities Division of the IRS. He specialized in 403B, 457, and governmental plans. Ed is a CPA working in independent practice, and he has a bachelor's in accounting from the University of Kentucky. And I don't know your length of service in the industry from the exact number of years from the bioed, but I'm sure it's extensive. How long have you been at this?
I think it was 50.
Well, now, Bob likes to say 50 because we were at it about the same length of time, so whatever he says is fine. But we were both in it over 30 years.
There we go. So they're neophytes, but they can help.
When I met you.
Continuing on down to the right, we have Scott Halbin, and Scott is the Chief Operating Officer of JEM, a fee-only TPA that does a lot of great work in 403B administration. And he's been with JEM since 2002 and is responsible for all of their defined contribution plans in terms of the operating and particularly for TPA compliance services. And he also has a bachelor's degree from the University of Texas at Austin, and since I'm a native Austinite, that makes me like him. And then rounding out the panel, we have Kim Selecki, who's a senior consultant at the ING Technical Services team, has nearly 20 years of experience in the industry working on technical, legislative, and regulatory issues. She's a graduate of Eastern Connecticut State University and has a master's in human resources management from BU. Is also a holder of the CEBS designation. Any mistakes, guys? Anything I left out? Hobbies? Anyone an avid skier? Or okay. So with that said, I think it's time to turn it on over to Bob to lead us off. And so I'll take a back seat and hand it off.
Well, thank you very much. We're going to talk about examinations, of course, in 403B with a smattering just to entice those who are interested into 457B governmental plans. And the best place to begin, I think, is looking at what's brand new. The 403B regulations were finalized in 2009. They went into effect. But the most important part of those regulations was really the new requirement that 403B maintained. It had to be maintained pursuant to a written plan. So what happens, there was a lot of pushback from folks in industry and certainly people who maintain 403Bs that more time was needed. So the written plan requirement came in another year after the regulations were finally effective, and the written plan requirement started in January 1st of 2010. But it wouldn't be telling the whole story if we said, okay, the regulations require 403B to be maintained pursuant to a written plan. A requirement, by the way, that had already existed for a number of years in 457B governmental plans. So we've got this requirement for 403B. But what I want to tell you today is, what does it really mean? Is it just another piece of wording in a regulation? It's a lot more than that, because the written plan requirement created new examination issues, effective, of course, January 1st, 2010, examination issues that had never existed in 403B before. Remember, as the gentleman was saying, as Ben was saying, I worked in 403B since 1978. Yes, people had written plans if they wanted to have written plans. Questions would constantly come into me when new pieces of legislation affecting 403B went into effect, and they'd say, Bob, when do I have to have language in my plan that goes ahead and meets these legislative mandates? And then they would read me language and say, is this language good? And I would always say, I can't tell you when or what type of language has to be in a plan that doesn't have to exist. It was really a very interesting thing. People like Ed, who was an IRS examiner, were able to go ahead all those years and examine the written form of a 401k plan, for example. But those issues never came up in 403B. And it's a kind of funny thing because, you know, Ed, every once in a while we'd have a new examiner, a guy named Andy, for example. I think you know who I mean. And they would go out there and they would start examining the language of the plan as if they had a 401k. And I'd say to them, and I had to say it politely, I'd say, well, you know, you really can't go down that path. And their manager would be upset that they just wasted 3 or 4 weeks doing it. I said, you really can't go down that path because there was no IRS requirement, regulations or legislation, that you needed a written plan. So new things happened. So why did the IRS, just as a little background story, put in this inane idea that you have to have a written plan? Because Congress teased this up when, in 1986, in the Tax Reform Act of 1986, is the first time, effective for years 1989 and after, that the word 403B is connected with the word plan. And when regulations were issued, which consolidate all the years of legislation since the original regulations in 1964, we felt it important that we go ahead and use the word written plan, that's what Congress intended. 403B to be maintained by, just as your other defined contribution plans, just as your defined benefit plans. It was required that they be in writing. Now 403B has to be in writing. But what actually does that mean, again, from an examination standpoint? It means that for the very first time, an IRS agent could get into the issues of form or document compliance. That's what it's called, document compliance. Does your actual plan, your document, have the right words? In other words, from the get-go, from the start, does it have the right words, which presents a new challenge for those of you who either service or maintain 403Bs for your participants. We've always known, as I've addressed at NAGDCA conferences in the past, that you always had to have operational compliance. That's easy. Are you within, well, sometimes easy. Are you within the monetary limits? Do you allow everyone who's eligible to otherwise participate? Have you monitored loan limits to the degree that they don't exceed the dollar limits they're allowed? All these other issues were always operational issues. But now 403B is on the same footing as, let's say, its larger cousin, 401K. Do you have the right language? So think of it as a coin with two sides, one being operational and one being form. And believe me, as we move forward, the form is equally as important as the operation. So what are the new exam issues? Well, what they are tools that goes into an agent's toolbox to do exams. One, of course, is the plan something that has been timely adopted? That means, has it been appropriately adopted no later than 1/1/10 going forward? In other words, as of midnight, 12/31/09, did you have a written plan that you adopted? And what this means to help in any examination, as Ed could clearly tell you, is that you need to memorialize that adoption took place prior, 1 minute before midnight, 12/31/09, and that adoption was done by the appropriate authority within your university or district that allows you to go ahead and do this and adopt a plan. And that little piece of paper, I can guarantee, is something an agent would want to see during the course of an examination. Was it properly adopted by the appropriate authority by the right time? 1/1/10. And this is important to remember as we move forward, because I'm going to go into little things in a few moments that dovetail with this to show what the IRS is doing in regard to that timely adoption, including a very rare item, an IRS sale. And you don't need a coupon. But next thing is form compliance. Again, a new issue. Those are the key issues. Are the words right? Do you have the right words? Now we're going to talk about what's the challenge of getting those words right and the tools that the IRS has out there on the web, very simply, free of charge, to allow you and help you to get those words right. And of course, operational compliance, but now we have a new thing with the word operation in it, and that means operating in accordance with the terms of your plan. This is something brand new, because in the past, again, prior to 1/1/10, even though novice examiners would think it did, this issue never ever applied. For example, let's assume you have a plan that says, specifically in the plan language, we do not provide for offering loans, period. You say this affirmatively in your plan. Yet your plan is funded, for example, by 5 vendors. The vendors have multiple products that they offer to participants in the plan. One of those products permits loans. If that individual takes a loan, the plan is not operating in accordance with its terms. So it's very important and presents the new challenge that you are able to reconcile the contracts of vendors that fund the plan with the language of the plan. They have to work together because, again, that third and brand new exam issue is the plan operating in accordance with its terms? So when we look at the written plan requirement, let's look beyond those words and see what the true significance of this requirement is vis-a-vis the people who are sponsoring these, offering them to participants. Are they meeting these new exam requirements? As I'm sure Ed will tell you when he'll be going into some of his materials, that is something that's probably already being examined. Right. So what you look for then in this is, again, what it presents. Now, let's look at current IRS exam activity. And this is important. Now, again, this is going to be built upon by other panel members, but I do want to tee it up because the cash cow yesterday, today, and tomorrow of IRS exams, Ed, correct me if I'm wrong, is called universal availability. The universal availability requirement, in fact, when we go into some of the tools the IRS uses for exams, for example, the compliance unit, a correspondence unit, we'll talk about what they actually did with this universal availability requirement. But universal availability, again, is always there, is there today, and always will. And it's a very, very simple requirement. It's really a requirement that we like to call elective contributions. You're electing to reduce your salary. Elective non-discrimination. Elective non-discrimination. You know, it's interesting. In 1997, Congress gave a bye to the public area in regard to discrimination. However, they did not give this pass in regard to elective salary reduction, non-discrimination, and in 403B is what we're talking about. In 403B, and this issue does not exist in 457B governmental plans, but in 403B, it does exist. And what it simply says is if one half of the room has the opportunity to make elective deferrals to their 403B retirement program, the other half of the room has to be given that same opportunity unless they fall into varying permissively excludable groups. The easiest way of dealing with this is let anyone participate. But there are many organizations in government that wish to exclude numbers of groups, and those who ordinarily work less than 20 hours a week could be excluded. The one that always comes to mind and the one a lot of trouble comes out of are in the K through 12 area, your substitute teachers. Also, in other areas, let's say misclassifying folks at university who should be employees but are misclassified as students because students fall into permissively excludable groups. And that's what universal availability is all about. And this is the biggest, the main IRS issue in 403B, and probably, and we'll talk about later when we talk about how you correct these darn problems, probably one of the more expensive ones to correct that you have to get.
The most expensive.
The most expensive that you have to correct. And part of this universal availability rule would be known as effective communication and opportunity. So think of universal availability as three things. One, if I wish to exclude people, and you don't have to, all of your common law employees can be included, not your independent contractors, not your leased employees, but your common law employees. So one, have I excluded if I wish to, by appropriate plan language? Remember, everything has to be in writing now. Have I excluded the right groups of people? That's number one. And if the answer is yes, the next question you have to ask yourself in vis-a-vis effective communication, have I communicated to my people in a reasonable manner the opportunity to make these elective deferrals? Now, here's the rub. The IRS does not tell you what's reasonable communication. But what isn't reasonable communications, and agents have heard this before when they go in for an exam, is where people in human resources or the payroll office might say, well, if they asked, we would tell them. But that's not it. It has to be some form of affirmative reach out that is reasonable under the circumstances with your particular employees. And that's what's known as effective communication. And one of the things IRS will look for, and we'll talk more about this when we get into the nitty-gritty of the examinations. Also, effective opportunity. That's another one. For example, people are supposed to participate in the plan immediately. Well, really, what does immediately mean? It means during an administratively feasible period, and recent language that the IRS has put out, which we'll talk about later, actually uses the 90-day period as if it happens within 90 days, if they're able to make those elective deferrals within 90 days after hire, that's going to be pretty reasonable. But here's an example of something that isn't, and something to watch out for. And this was a real question I had received from a Institute of Higher Education. Their plan permitted people to enter into it on February of every year. They hired someone new in March, and they held out the ability to make elective deferrals to the next February. That's not going to work. Effective opportunity, again, means with an administratively feasible period, but some of the later things that the IRS has actually put in writing says, don't go beyond 90 days from when they're first hired. And certainly don't write in that you have a 90-day waiting period. It's really just an administrative period, and they can make those elective deferrals as soon as they're able to within that administrative period.
Bob, just one point. If you're going to use 90 days, use it for everyone. Don't let executives, others come in. It's one 90-day period that you apply to all of your employees.
I might have missed it, but what's the difference between a common law employee and a regular employee?
A regular employee basically is a common law employee. I'll give you a perfect example. When we get into this compliance unit and we hear how it operates, we're going to find out an interesting thing. They sent out letters to see if people were in compliance with this universal availability. What happens is, one school system said, we exclude our bus drivers. So they get a follow-up letter, everybody's concerned, well, they must have an error. But then they write back at some later point that the bus drivers are leased. Well, they're not their common law employees, they're not their regular employees, so they never had a problem, but nobody realized in human resources to say when they're filling out the questionnaire, and Ed, you'll be going into that questionnaire, when they fill out the questionnaire, just say, you don't have a problem if they're leased. So having a little knowledge about this is great when you're dealing with the IRS, because you could forestall getting into further problems and follow-ups. Okay. Go ahead.
To that point, Bob, I want to point out that if you do exclude employees that work less than 20 hours a week, you actually have to go back and make sure that those employees actually work less than 1,000 hours in a given year, because if they work more than 1,000 hours, they then become eligible for the following year, and you need to communicate that to them and make sure that they know that they're eligible for the plan going forward.
Yeah, years ago when Ed and I worked at the IRS, we always told people, is it that important to exclude anyone? I mean, there are a lot of folks who, like, for example, substitute teachers in K through 12, who are not going to reduce their salaries, who are not going to do this. But I know in my county, they had a term known as regular subs, and they had people there who worked 1,600 hours a year who absolutely would have been otherwise entitled to make the elective deferrals. So I've never think it's worth it to come up with the language in the plan and the trouble it takes to exclude people, because at universities we've also seen people who might be in one group today, but tomorrow they may be in another group that's eligible. So really, what's the point? Playing it safe is to let everyone in and let people decide if they wish to reduce their salaries. The folks that you probably would have otherwise excluded probably would not anyway. Okay.
Can I,
Yeah,
before we hop
sure.
on, I see a lot of nodding heads and some furrowed brows. We've gone through a couple of these definitions. Are there any questions thus far about any of these terms that we can maybe answer? You first, and then you, sir.
Not so much about the terms, but I had a question about who can be excluded. My Virginia locality has a 457B plan, and in 2014, Virginia law says all new hires have to participate in a state defined benefit plan. We don't want to have to deal with the logistics of having them participate in a state plan and our plan and making sure they don't go over the limits. Can we change our plan documents and exclude them since it's a 457?
You have the opportunity also to exclude those who are eligible to make elective deferrals under another type of plan that permits elective deferrals. For example, 457, assuming it permits elective deferrals. 401k, whoever happens to have one. So if you have people who can make elective deferrals under another plan, they may indeed be excluded from the 403B.
Thank you.
Okay.
And we had a question in the back as well, if we could.
This might actually follow up with that.
Let's see if we can get the mic over to you. Thanks so much.
Thank you. Concerning universal availability, is it exclusively to 403B? If you have, say, a 457B available to employees,
No problem.
but would they have to be identified in the 403B document as an excluded group, or just because they have it available to them, you're covered?
The 403B should actually say, my advice would be to say in language, since it has to be a written plan, that you exclude those who are otherwise eligible to make elective deferrals under the plans you enumerate within the plan document, and you will not have a problem. Just happening to do it by operation of law, that could be a problem, because we're really dealing with a written plan. So anything you want to happen or not to happen has to be spelled out in the plan.
Okay, but in that case then, if somebody who was participating in the 457 were to elect to go into the 403B, it would be a failure?
It would be available if your plan
No, he said would it be a failure?
Oh, a failure, a failure. If your plan actually says that you exclude those who have the ability to make elective deferrals under the 457B that you enumerate, then having them make elective deferrals under the 403B would not be operating in accordance with the terms of the plan and would present a problem.
Okay, thank you.
Yeah, if you're excluding a group, you're excluding it. Absolutely.
Okay.
So careful what you wish for. By the way, as Ben was saying, this is an open forum, so at any point, someone back there,
If we don't know the answer,
Yeah.
Bob will make it up.
I
We have-
always do.
Yeah, we have a raised hand back there as well. And if not, I'll make a joke about it.
So how does that work for 457 plans? Can 457 plans exclude as well?
457 is a beautiful world. It's like Nirvana. It can do what you want. It's wonderful. You
my
can
note.
have a 457 where I say, you could participate, but nah, I don't like you to. You can't participate. 457 doesn't, isn't that beautiful? It does not have the issue of non-discrimination, elective or otherwise. That concept doesn't exist. So if you want to go around and tap people on the head or play a game of musical chairs and the last one gets the 457, the others don't, whatever you'd like.
Okay.
Pretty strong endorsement for 457. It's like Nirvana. I'm going to try and find something where I can publish that later and quote you, Bob.
Absolutely.
Any other questions before we move on? I just wanted to make sure as we're setting foundational terms for some that we have clarity.
At any point, just come in and interrupt. Interrupt Ed more than you interrupt me.
Yeah,
That's okay.
please raise hands as well. We'll pause and note the questions when there's a good stopping point.
Absolutely. Ben, can you get on to the next one?
Absolutely.
Sounds good.
All right. Carry on.
Okay, now one of the things I was talking about is how all of this dovetails together. You have a written plan requirement. So, well, what happens if you don't quite get those words right? What actually happens if you don't get the words right with this written plan requirement? But the thing is, the IRS has a way of correcting problems. And that correction system, if you want to hear the acronym IRS uses, is EPCRS. Very simply put, the Employee Plans Correction Resolution System. This system has been around for many, many years. It has applied to 403B since 1999. 403B has been a part of this correction resolution system since 1999. For those of you who really love history, from 95 to 99, 403B had its own. But in 1999, it joined the bigger folks in this employee plans correction resolution system. Theoretically, a new incantation of that revenue procedure, by the way, that's not a scary word. Revenue procedure is nothing more than the IRS terminology for an instruction manual, a lot better than IKEA, I would say, for an instruction manual of how to do something. That's what a revenue procedure really is, nothing to fear. And the IRS would come out with a revenue procedure, which was the instruction manual to how this resolution system operates. And they were supposed to come out with one that's new every year. The last one was in 2008. Okay, remember, those IRS regulations for 403B went into effect 1109, okay? The written plan, 1110. But now you're scratching your head and said, wait a minute, we need a new correction resolution system that includes 403B to address new problems. I just showed you those new exam issues that came in. We need something to address new problems and other regulatory issues that were raised by those 403B regulations in 2009. And yet, 2009 came and went, 2010, 11, 12. Where is the new revenue procedure for this correction system? Well, it finally came out the beginning of this year, known as Revenue Procedure, I'd like to call it Instruction Bulletin 2013-12. Came out, announced in January, and this new correction system contains ways to correct defects that will arise under your 403B in the world of the regulations and the written plan requirement that was part of it. 2009, 2010, now all this is included. And if there's anything funny with the IRS, it's this one. Remember we talked about the untimely adoption. Well, this system allows you to correct for an untimely adoption. And this is IRS humor. If you do it by the end of this year, you get 50% off on your fee. No kidding. This system very simply allows for two regimens. One, self-correction, and the other, Internal Revenue Service approved correction. So there are two parts of it. They talk about defects that can be self-corrected, and they talk about defects that somebody has to come in, forms are in the instruction manual, come into the Internal Revenue Service, pay a fee, not inordinately large, but still a fee to do this correction. And the IRS is saying that if you have an untimely adoption, you can fix it. Don't wait for the examiner to come around because it'll cost you more. But you could fix it, and if you fix it by the end of the year under the system by an application to the IRS, you get 50% off on your fee. And they don't even require a coupon from your Sunday newspaper. That is unbelievable.
Right, and just to point out, you will not get the 50% off if you're audited and you haven't adopted.
That's right. That's right. So, this correction resolution system, again, reflects the new regulations, but it doesn't only concentrate on items such as document requirement? In other words, is the language right? It goes into other areas. There are too numerous examples, but the one I like best is the in-service contract exchanges. They're set out, the new regimen of doing that is set out in the regulations, and one of the requirements are something called an information sharing agreement when you do this. And let's say you fail to have one, well, you could correct under this correction resolution system. In fact, it's pretty open-ended, and any new problems that happen under the regulations because of your trying to comply with those regulations can be corrected under this system, just that some are for self-correction, some require an application and are service-approved correction. So for those of you, and you wouldn't be at NAGDA if you didn't love the numbers 4, 5, 7, for those of you who, of course, are wondering, well, can I use this system for my 457 plan? And the answer is you can use the principles of the system if you're correcting. But this program does not allow for actual application to the IRS in regard to 457B governmental issues. And why is that? Because the IRS is mean? No. It's because of the fact that as governmental folks in the world of 457B, you have that wonderful, unique provision that says 180 days after an examiner, I keep pointing to him, but he's retired, he's okay now. After an examiner notifies you that something is wrong, a 180-day period starts to click, which basically means if no one notifies you, well, you don't really, if you don't want to, there's no need to, or time frame in which to correct. You could correct whenever you please, but the point is that if an IRS examiner during an exam does notify you in 457B that there's defect, you'd have 180 days to self-correct that defect. And that's the reason why you will never really see 457B as part of an official 2013-12 revenue procedure IRS correction system, because Congress built in the statute the very language that you need to do it yourself with a very, very generous time frame. But a lot of folks in 457 over the years have certainly asked myself and Ed the question of, well, how do I do it? Well, in this correction resolution system, they say, hey, feel free to use the principles of 2013-12 should you be dealing with a 457B correction. But right now, what we're talking about officially on self-correction, service-approved correction, this is for 403B, and what it does is it updates the procedure to allow for all sorts of 403B defects, even those no one even thought about under the new regulations. So that's extremely important, and it brings in all those new issues. The new issues, am I operating in accordance with the terms of the plan? Do I need a retroactive amendment to change the way I've been operating? Have I timely adopted? All these type of things. Do I have the right words, the right language, my document compliance? That can be fixed under this system. Okay, so what else is new? What else is good to talk about before we get into the absolute trenches on how these exams work and what goes on? What else is good to talk about? And what else is good to talk about was something that was also long anticipated and hoped for by the 403B community. Remember, we talked about 403B a few moments ago as a two-sided coin. Operational compliance, something we were always burdened with, dollar limits, all this stuff, universal availability. But that new side of the coin, talking about document or form compliance, that has existed in other plans for many, many, many years. It's existed for some years in 457B governmental plans. It's required to have a written plan. IRS even put out sample plan language in the summer of 2003. Okay. It existed certainly in all your 401A defined contribution plans, defined benefit plans, 401Ks, all of this document compliance. But it happened that in your 401A area, IRS provided a way to make it easy for you, and it's called a pre-approved program. What if IRS said from the get-go, with Reliance, by the way, IRS carries the best form of malpractice insurance, because if they err and they later come to you and say, this is really no good, as long as you have that letter, you have Reliance. As long as there's been no material misrepresentation in your application for approval of a plan, you have that letter. And they don't go back on their word. They'll go forward, but they won't go back on their word. Okay, so what if you had a program that you could pre-approve, that you knew from the get-go that your language, that document wording in 403B is good? Just like IRS has been saying for other type of plans for many, many, many years. I worked on the first 401k, not to age myself, I did this while I was in high school. I worked on the first 401k pre-approved program in 1976. But, you know, they were hiring young that day. Right. But nevertheless, what happens is you've got this ability to get a pre-approval, but this never existed in 403B. In 2009, IRS came out and said, we are going to have a program to pre-approve the language of your 403B. Everyone went, yay. 2009. 2010, 2011, 2012. Finally, in 2013, IRS came out with another instruction manual, IRS Revenue Procedure 2013-22. Now we're going to have a pre-approved program. It was announced in March. It was effective in April, open to submissions not that long ago, June 28th, June 29th, get my glasses on and see that, 28th. And it allowed for submissions for a pre-approval by investment and service providers and other organizations. Well, let's talk for a moment of what that does for you. What good does that do for you if, for example, the company I work for or some of the other companies represented at this table make a submission and get a letter from an IRS agent that says, hey, it's good? What does that do for you? Well, what it does for you is this. The way these procedures work, generally, when the letters are issued, organizations maintaining 403B will have approximately a year's time, maybe more, but at least a year's time, most likely, to adopt one of these plans that any of the organizations who submitted and got approval offer you. You will have the ability to adopt one of these plans, which leads me into the question, and you'll hear it today, well, we have a prototype 403B you might read on the web or hear at a conference that we'd like to sell to your organization. Well, you know, that's just like the difference between the Franklin Mint and the US Mint. There are no IRS-approved prototypes right now. Before you leave this room, if there's anything you want to come away with, if people try to sell your organization something, there are no IRS-approved prototype 403Bs now. That doesn't exist. They will one day. Okay, the applications are currently being submitted to the Internal Revenue Service by the varying vendors, providers of benefits, other organizations, and they seek pre-approval, under certain types of words. I don't want to go into the technical nomenclature, whether something's a prototype, whether something's standardized or non-standardized. All we know is that these organizations are applying to the IRS as we speak, not on Sunday, to look for pre-approval. When they get this pre-approval, and it's all going to happen at once. IRS said a long time ago when they first announced this program that all this pre-approval will happen at once, no matter when. Let's say, for example, Valak submitted an application. ING submitted an application. It doesn't matter time-wise because all those letters of approval will go out at the same time. So nobody has a competitive advantage, and it's very important to understand. IRS thinks it's going to take about 2 years to get those letters out. Nothing happens quickly. And with sequestering, maybe even longer. But they're figuring maybe 2 years to get those letters out. Then, if you all have an extra year in which to adopt the plan, that's 3 years. So what we're really talking about is what's coming on the horizon, but that's something very important to think about. This carries an amazing advantage that I'll get to in a moment, but what I want to get to is our other friend, 457B. Do we have a pre-approved program for 457B? And if not, will we ever have one? Well, the bottom line is there is no pre-approved program for 457Bs yet. You still have to have a written plan that has the right language. IRS did help a little bit with model language for 457 that was issued soon after the 2003 regulations were finalized, back about 10 years ago. But that's it. There's not going to be a pre-approved program for 457B governmental plans. There won't be, and there's nothing on the horizon, and there's really nothing behind it. So that's important to understand. This new revenue procedure is 2013-22 is for 403B, and I know most everyone in this room juggles both 457 and 403B and a number of other things too. Let's take a look at this guidance, this revenue procedure, the instruction manual. And what we're really talking about is when employers finally, within that year, after the 2 years, and this is 2013, so we're figuring, let's say the letters go out in 2015, and let's say, hopefully I'll be long retired again by that point, and let's say you adopt it by 2016, what do you get? You get Reliance, that the letter that the company who submitted it got now brings you Reliance that the 403B is good as to form, which means if you're ever unfortunate enough to have an examiner come there to your place of business, by the way, always sit them by the break room because the sound of the Coca-Cola's dropping in the machine drives them nuts. And they could be there up to a year, right?
Or more.
Yeah, or more. So you kind of want to, think about this. But what happens is you now have Reliance, even if an examiner says, well, I don't like that language. Well, you have Reliance. You now have adopted a pre-approved plan that has Reliance. But there's something way more important than that. And all of this dovetails together at this point. Remember what I first said, you have to have that written plan in place, good as to form as of 1/1/10. 1/1/10. So all this time you're going along, and maybe the language isn't the best, but you adopt one of these prototypes, and this is unique to this program. You now can remedially amend your plan all the way back to that first date of jeopardy, January 1st, 2010, and you could be in the year 2016, as we were talking about. When you adopt one of these things, you can now, by the adoption, remedially amend your plan back to say you've had the right language all along. You've had the right language all along. So what happens if during this time, and we're talking about 2010 to 2016, almost 6 years. What happens in the course of that time if an IRS examiner shows up, and among the issues that he or she examines is the wording of the plan, and they tell you that the wording of your plan is incorrect, and they begin to write it up as a defect? What the IRS has said in this revenue procedure basically is, and through public pronouncements continuing from the Director of Examinations, they have said that if you tell that agent that sometime in the future, when it's available, you are going to timely adopt a pre-approved plan, that agent cannot go on and make that as a defect.
Absolutely true, but that doesn't mean the IRS will leave you alone.
No, what they will do is they will take your name, address, and phone number. But every once in a while, agents retire, and the list they carry in their back pocket goes to the dry cleaner. So, do we know of any compendium where they're keeping the...
Well, actually, there is. But
In your house again?
no, once you leave your list. No, actually, what's going to happen if they are out there and the IRS notices that you have some form defects, and you really want them to, because if you've got form defects, you know, Bob talked about, oh, we're going to correct it retroactive to 1/1/2010. Well, that's right, but you have to correct the operational. So, if they notice that you have form defects, then they're going to bring those to your attention. You don't have to make an amendment, but you can make an amendment so that you won't end up having an operational problem.
Yeah, one thing that you do want to be sure of, and that is to consider that if you have form defects, you must ask the question, have they produced operational defects? That's extremely important. But the important thing is, let's say everything operated perfectly, the question is someone doesn't like the language, they can't call it as a defect today if you affirmatively tell them that you intend, by the appropriate time, to adopt a pre-approved plan. That's extremely, extremely important. The advantage of this program do not only come, let's say, in 2016, but if you're in that form of jeopardy, they could come today. Now, the question everyone asked is, what if I don't want a sort of cookie-cutter pre-approved plan? And many of the vendors are actually going to produce plans that fit the varying industries: government, K through 12, higher ed, the religious sector of higher ed, etc., all of this. It's not going to be, in many, many instances, cookie cutter. But what if you say, I want to sit down with my attorneys and design my own individually designed plan? Well, we know that if you have a 401A, defined contribution, defined benefit plan, you can do that, and you can go to the IRS, and you can get a pre-approved letter saying this plan is good as to form. Unfortunately, that has not been carried over to 403B. IRS says they do not have the resources. So while originally in 2009, they announced that a pre-approved program would include individually designed plans. Unfortunately, I like to think it's because I left, but unfortunately, that is no longer on the table. IRS does not today nor tomorrow have a program that accommodates pre-approved individually designed plans. There are more of these mass submitter, or what they call prototype plans, if you want to get bogged into the nomenclature. But really, unfortunately, that won't happen. Now, another very important advantage of this program, and understand, you do not have to have one of these to do business in 403B. Today, for example, you don't have to have a letter. No one ever said you did to do business in 401A. You don't have to. You want one, yeah, but you don't have to. But you don't have to have one of these, but it provides an amazing advantage. It provides not only the ability to go all the way back, remedially amending to January 1st, 2010, but it also provides less work for you. Because one of the things that the program does is put the onus for oversight as laws change on the submitter, on the company, on the ING, on the VALIC. They put the onus on the submitter. So now they have to go ahead and notify you when laws change, when different things happen, to keep your plan up to date. Submitter oversight, that's extremely important. So do you want to know about this program if you're going to be around in 403B? Yes. Do you want to partake in it? I don't see a downside. But remember, it's not for individually designed plans. Now, we put out a lot of information here, and I don't want to go past this point without asking if there are questions, any confusions that could be cleared up, anything that could be going into. We have a lot of knowledge up here, so we'll be happy to help.
You have a question on the your right side of the room?
You mentioned for 457 plans that you get the notification from the IRS, you have 180 days to self-correct. If you do so, you avoid all IRS fees and penalties?
When we say you have an ability to self-correct, I'm going to say that within that 180-day period, you don't have a defect, and therefore, you've corrected.
Right.
Now, there may be a cost to you of correcting.
Sure, I
Just
understand that, but not cutting a check to
not
the
from
IRS.
Not from the, no.
Thank
no.
you.
Other questions? Was that you?
Bob, may I ask a question?
Absolutely.
In your opinion, is the binder clip approach still a viable option in satisfying the written plan requirement?
Right, what Kimberly is referring to is known also colloquially as the paperclip approach. And what IRS has always said, and I still maintain all these years later, is that a written plan can be a compendium of varying things. For example, your vendor's contracts, your salary reduction agreement, your internal operating procedures. Perhaps if all these were clipped together, they would satisfy the rules of the regulations on 403B. But as I have to respond to Kimberly, this is a theory because in honesty, I've never seen one that would meet all of the requirements. I've never seen a contract that goes into the non-discrimination rules. I've never seen a salary reduction agreement that basically will contain all of the language that would satisfy universal availability. So yes, there is a theory that if all of these items were clipped together, and you'd still need a resolution adopting these timely by 1/1/10 to satisfy the IRS, yes, theoretically, you could satisfy that written plan requirement. Again, paperclip approach I find viable, but to date, I haven't seen one. Have you seen one?
No. So pragmatically, no.
Well, I'm not going to say no. Theoretically, yes.
Theoretically, yes.
Well, let's put it this
Practically,
way. If you
no.
were under audit, I'd certainly be looking at that to see if possibly I did have a paper clip that would work.
Right.
You hadn't adopted a plan.
But again, there are, as we go into, and certainly can be gleaned from the regulations, there are provisions that are required to be in a plan. For example, eligibility, settlement options. Now, a lot of these things, certainly settlement options, can be found in the vendor's contract. There's no issue about that. But for example, eligibility, I don't know. But what I'm saying is there are many optional provisions in the plan. Loans, for example, hardship distributions, all these type of things. These are optional. But we know, as Ed, for example, when he examined, looking at a plan, there are certain things that need to be there to have a plan. Now, if the paperclip will satisfy that, I haven't seen one yet, is all I could say, and Kimberly hasn't seen one, and between us, we don't want to age ourselves. We have, what, 14 years experience? Plus.
At least.
Yeah, at least. Okay. Well, if there aren't any other questions, we will move into the...
Another question right there
we
on the
got
left
one
side of the
here.
room.
Okay.
Go back to universal availability a little bit if we could. First, you touched on the pitfalls of misclassification of a student, but didn't really help define that.
Right.
Can you give some examples of where a higher ed institution could get tripped up on excluding students?
I'm going to ask Ed to fill in, but I'm going to begin with the issues where, for example, we have those who work with a professor teaching assistants. And it becomes an issue of how fine the line is crossed, taking that person from a student into really a position of employee. The bigger question to this area comes in with employment taxes. That's where you really get into this, employment taxes. But it does spill into 403B, because if an employment tax exam is held, and I'm going to ask Ed, because he's been involved in some of them, what actually is looked for during the course of the exam. But if, as a result of the employment tax, it really comes up that for X amount of time, this person has not been a student, and your plan calls for the exclusion of students in this university, for example, what happens is you're going to fail universal availability. Ed, do you want to go into some of the employment tax issues?
Well, it is something that the employment tax examiners look for, because the students that you are excluding are those that are excludable for FICA taxes. And so if an employment tax agent is out there from the IRS, that's something they're going to be looking at. And so we'll just kick off, Bob's, what he's talked about, you got your plan together, that's the easy part. Now you got to operate this, and you got to be ready for an audit. So myself and Scott and Kelly are going to talk about and interact with is all of the interactions you might have with the IRS, and I'll just start off talking about the initial contact. So if you go to that slide. There we go. You think about audits for the IRS, and the first three are audit activities, and that's where you come in contact for the IRS. The employee plans audit, that's for your deferred compensation. Your 403B, as we're talking about here. And so that seems obvious. Yes, if you've got an employee plans examiner there from the IRS, then you're having an audit on your deferred comp. If you're having an employment tax audit, that's the Fed, state, and local government division. Okay, well, since I taught all of their non-qualified deferred comp taxation before I left, I'm very familiar with the Fed, state, and local government employment tax people. They routinely look to see if your student classifications are viable, if you're not following the FICA rules, and they come up with individuals who are not students, they're required to contact the employee plans division of the IRS. So here comes your deferred comp being brought into this audit for employment taxes. So anything that you do with classification for employment tax, you classify people as independent contractors. I encourage people today. I encourage people. It's the first thing I ask when I'm out on consulting with them is, do you have rules and you're following them, and are you feeling pretty confident that these are really individuals who are independent contractors? Because IRS comes in, reclassifies those, you're automatically going to fail universal availability on your 403B. Not anything you can do about it. You'll see these provisions in your 401A plan stating that if the IRS reclassifies someone as an employee, they still will not be a participant in the plan. Won't work for 403B. As a matter of fact, if you actually have that in your document, you've got a form defect. So that's one way an IRS audit still, for employment tax, still brings in your deferred comp. The exempt organization audits. Now you think, well, they work with 501c3 organizations. They audit the 990Ts for college and universities. And so if they're in for one of those audits, they have their own employment tax people. They routinely, if you remember the college and university audits that were ongoing the last couple of years, an employee plans person was assigned to all of those audits to at least see if there might be any problem. So there's an interaction. But all of these audit touching by the IRS are real labor intensive. And so what I'm going to talk about is the Employee Plans Compliance Unit, EPCU acronym. And the IRS needed to have employers be able to know that they might have a problem and provide them some guidance, and also show Congress that they were touching more people with keeping them up to date. So that's what why they set up this employee plans compliance unit. So what that employee plan compliance unit does is take a small number of people that's not as costly for the IRS, contact a lot more employers, doesn't tie up as much of your time, and then possibly identify to you that you have a problem, and then you can correct it under these correction procedures Bob mentioned under the EPCRS.
Let me, can I just add
Yep.
one quick thing before Ed goes into the actual project selection? Let me just say, and I don't want to touch on what you're going to be talking about, one of the projects involved 403B, and to show you the reach of this unit, I mean, how many real live examiners can be sent out? That's very limited, boots on the ground. But with letters, it's a lot easier. There are, for example, over 15,000 independent K through 12 school districts in the United States. Through this program, IRS reached about 5,500.
Right. So, you know, the compliance check is a good way for the IRS to leverage resources. It's not going away. But they're not audits. So then you wonder, okay, how does the IRS decide what they're going to run for a compliance check? Well, you can go to the IRS website and you can see the list of the compliance checks. And there's also a place there where you can suggest compliance check items. So they receive input from both external and internal in the IRS about, inside the IRS, what might be a good project. So the IRS auditors are out. They're noticing that there appears to be some sort of problem in retirement plans. And since we're talking about 403B, there's some sort of problem going on. How broad is this? How can we get the information out? When the IRS has to issue notices, revenue procedures, that takes a lot of time. They find out they've got a problem through this EPCU unit. They can do customer education and outreach materials, posted on their website, check sheets, this sort of thing. So from their perspective, it seems like a good use of dollars. Now, when they finally decide, they've got all the input, they decide on how they're going to select, it's no one person. It's basically comes down to all the directors of employee plans, the director of employee plans, director of EP examinations, the director of rulings and agreement, all the area managers. So I mean, it's a large number of people that sit down, review these, and decide, okay, here's the projects that we'll approve. So therefore, I mean, that's how employee plans work. I know you're thinking, I heard how they do things on the TV, but this is how this works. So there's a large number of people approving these projects, and there's a lot of documentation showing how they were determined. So let's move on to the next slide. So what does, and I'll just ask, has anyone in here ever received one of the EPCU letters? No? Okay. So, you know, what does a compliance check look like? It's a letter. It's a letter going out telling you it's not an audit, and then with a list of, an attachment has a list of questions. And so it's got a questionnaire, and they're going to ask you the questions. It's very important that you fill out the questions correctly. Scott had a comment.
Correct. We tell our clients as the third-party administrator, it is better to not respond at all than it is to respond incorrectly because you didn't understand the question. Many times, a plan sponsor gets the letter, reads through it, knows they have to fill it out and send it back, and just goes through and quickly answers and marks off what they think may be the case or what they think their policy is. Highly do not do that. Because if you enter something incorrectly, it will flag and cause you to get audited, and then you'll have problems when you incorrectly answer the question. So contact your administrator if you use a TPA, contact whoever runs the benefits program, and make sure you are filling it out correctly, because even though it's not an audit, it will trigger an audit if not completed correctly.
Well, it may not trigger an audit, but it may. But the main thing is get it right. Because if the IRS works from bogus data, they're going to get bogus results And then they may decide that we need to audit all the people that have this particular issue because 75% of them were incorrect. And
What happens if you don't respond?
well,
Or are you gonna get to that?
I'm going to get to that. Save that question. You'll like that answer. So now you've got the questionnaire, you filled it out correctly. What do you do with it? Well, you can mail it in, fax it in. Some of them may have an email address that you can send it to. The IRS gets your response, and they review it, and they do one of two things. They issue a letter saying no further action, or they issue you a letter that says, from your responses, you might have a problem. Remember, they're not looking at any books and records. You might have a problem, and if you have this problem, here's how you can find out, and here's how you should correct it. And then they're done. But if you have any questions, you contact that person who is sending the correspondence. If you don't respond, and the IRS has been pretty clear about this, you will receive an audit. And you'll find that, as we'll talk about it later on, any of the things that these compliance checks from EPCU have broadened into other of the tax exempt sector and federal, state, local government. So please respond to their inquiries because nothing good will come from not responding. So let's go to the next one. Now, prior projects impacting governmental employers. The first one, 403B, universal K through 12, you heard Bob mention it earlier. That was directly from EPCU asking those working with the 403B in the field and headquarters, what's a good project? We said universal availability, K through 12. They sent letters to public schools in all states and determined that there was a lot of universal availability problems. There was a lot of letters went out. That second letter saying, it looks like you've got a problem. Because a typical response would be, do you exclude anyone for hours? What's the hour work less than 30? You know, a typical benefit eligible requirement in government, you're not eligible for health insurance or the state retirement system unless you work 30 hours or more. Can't work that way for 403B. So, you know, that's how they would identify that there was a problem. Then they did a follow-up to the ones that they had identified might have a problem, sent a second letter to saying, look, by your answers, it looks like you might have had a problem. They did a follow-up saying, okay, we thought you might have had a problem. Did you find out that you did? And if so, how did you correct it? So that's how that went. That actually, they had such good results from the standpoint of there were problems and trying to get information out. They did a 403B universal availability for higher ed. You know, uncovering the same reason. There's no final report on it exactly, but they found similar issues in that you had individuals who were being excluded. They were excluding adjunct just universally. Adjuncts are not allowed to participate. They don't count the hours, don't look to see how many hours they work. And so there was a question at the bottom of that particular questionnaire that had nothing to do with universal availability. It just asked, do you have a 403B written plan and when did you adopt? And about 13% had not adopted the written plan after 2009. So just keep that in mind. Then there's a 401K questionnaire. The reason I mention that is because you have elective deferrals. And although this wasn't directed necessarily at governmental, items that they would find on elective deferrals for 401K, the errors for going over the limits apply to 403B. So you can find some good information in that. So let's flip to the next slide. Future projects. If you look on the IRS website, you'll see that there is a 403B plan document project that is approved. Obviously, until the remedial amendment period closes, you're not going to see that project go forward, but it is sitting there approved. So I think, down the road, you're going to see that they're going to send out letters wanting to know about, have you adopted your plans? The non-governmental 457B project. Now, it says non-governmental, but if they have results showing excess deferrals, unforeseeable emergency problems, in my opinion, and it is just my opinion, they're going to then say, we need to expand this and do a project for the governmental sector. They realize, if you look at what they state about this particular project, that they may also have some governmental employers in this project because that governmental employer has a 501c3 status. When Bob was talking about the plans and eligible employers and this sort of thing, you remember governmental higher ed, or education, not higher ed, education. Healthcare, so a county hospital can't have a 403B, but they can get a 501c3 status. Once they have the 501c3 status, then they can have a 403B. So you have hospitals sitting out there with a 501c3 status, having 457B, so they may be in this project. You can have schools that have 501c3 for grants. So they may have wrapped up some governmental employers inside this project already. So let's move to the next one.
Ed, can I just make
Yeah.
a comment? Just to your point, we have been contacted by at least 2 public schools that have received that particular
Okay.
letter. And if I'm understanding it correctly, there is instructions included in the letter what you should do if you receive it in error. So
Right.
I guess the suggestion.
Are they K through 12?
Yes.
Yeah, it's very common in the K through 12 sector for them to obtain 501c3 status because a lot of the grants that they apply for, they don't want to deal with whether or not they're a governmental employer. Show us a 501c3 letter, then you're eligible to apply for a grant. So there are a lot of public schools.
And how
have
should
that.
they respond to that?
Well, they can respond showing that they are a governmental
Okay.
employer and they have a dual status. And if you look at the IRS website, I mean, they actually recognize that we may have picked up dual status employer, but I don't think I don't remember now. I don't think it tells them not to complete. It just
No,
tells
it gives them instructions.
It gives them instructions.
If this does not apply to you, you should do this. So
Yeah,
I guess
I-
the point is do that.
I think what Kimberly is referring to, and we've seen some of them too, is not the dual status folks, but a true K through 12 who receive this because it just went out wrong.
Oh, okay.
Yeah, we've seen some of those too.
That's interesting because they were supposed to be pulling from the 501c3 listing.
And I'll ask one just to add on to that, Ed. So I know there's at least a couple of people here, and I think there's others that I may not know of that are working with states where they're offering basically participatory 403B, where you have access to multiple school districts. Who would receive these sorts of contacts, and who would be responding if you have a state that is also facilitating plans that school districts
Well,
can
it's going to
use?
go to their individual employers. It's going to be selected by employer, so it's going to go to that employer. Now, if someone else should respond, the employer should pass it up and explain it. But yeah, keep in mind, the way that the IRS would pull these would be by, they know from the W-2s that there's a 457B because of Box 12. Now, what they were supposed to do, since I have done this myself in a prior life, you run those listings against the 501c3 listing that we have internally, and you can tell a lot of things. So that's what they were supposed to have done. If someone's on the 501c3 listing, they would send a letter out from it, assuming that they were, but I don't know why, just a pure governmental got mixed up in that particular sector this time.
Yeah, they actually did. It was kind of humorous in a way that they just got letters, and I think it harkens back to something you and I both experienced when we we're looking at whether car dealerships, remember that one? We're putting in
Well, now, that's
457Bs.
improper completion W-2.
And it was improper completion of the W-2. Tell them about the car dealers.
Well, we want to move on to the audit scenario, but yeah, complete your W-2s correctly. You don't complete your W-2 correctly, you're going to enhance your opportunity for an audit. You put in box 12 your 403B and your 457 lump them together and put them under 403B, your chance of being selected for audit just went up significantly. So, and I think that's mine. No, one more. Yeah, impact on the other organizations. Do this really quickly. Exempt organization, the college and university questionnaire, that was directly from how the EPC unit had been operated. They've now set up their own compliance unit to do compliance checks. So compliance letters be coming out from exempt organization, Fed, state, and local government, working on their own compliance unit for compliance checks. So in the future, I would think that there'll be nothing but more compliance checks because, like I said, it's a cheap way to find out if there are problems. Yes, sir.
What is the current status of definition of a governmental employer?
The definition of a governmental employer. It's in the regulations, which are still in the proposed. So no end in sight currently, because even after they respond to these initial, then there'll be the proposed regs, and then there'll be the final regs. So I don't even know how many years that'll be working on, because there's a lot of complaints. Right. Charter schools is the number one question when you get in the K through 12 sector.
Yeah, I mean, you may be retired when they ever, if they ever come out with this. That's how long we're talking about. And the question of, yeah, they're trying. And the question of the charter schools, you know, they may not give you a full plate on that.
But I think it's now time to move into the meat of the administration. Let's move on to Scott.
All right, we're going to talk a little bit about what happens now when you're actually selected for an audit and what that's going to look like to the organization, what type of documentation is going to be required. You can move on.
Yep.
The next one's fine.
Yep. Can we turn the mic a little bit?
I'm sorry?
Can we turn the mic towards you a little bit?
Initially, you're going to receive a IDR, an information document request, which is basically going to be a probably 20 to 25 page packet from the IRS where they indicate that you're under audit. They're scheduling an initial audit meeting where they're probably going to have somebody on site come sit with you and talk to you and go through the processes. And they will request all of the documentation that we're going to describe here in a little bit. One thing to note, if your 403B plan gets audited and you also have a 457 plan, a FICA alternative plan, any kind of executive compensation plans, they're all going to be audited together by the same person at the same time. One thing to note, there is a date on the IDR that you will get that they want you to respond by. If you need more time than that, let them know. That's not a firm date. A lot of times we get requests where a school district gets a letter the first week of December. They want to meet first week of January, and the district's going to be closed for 2 or 3 weeks and not have access to that information. So if you need more time, and we're going to go in, it's a lot of documentation and a lot of information they're requesting, simply contact the auditor and let them know that so you can reschedule. One thing to note too, a lot of this information, depending on your organization and who you use as either a third-party administrator, a record keeper, how many investment providers you have in your plan, if you outsource your payroll to an outside payroll company, a lot of this information is going to come from different entities depending on your structure. So it's important to contact all of your service providers and make sure they're aware that you're being audited and what they can produce for you and what information you need from them. You can go on, Ben. So starting here with a document, obviously plan document first and foremost. Bob talked about, you're going to need that. You're also going to want a copy of all your service agreements or contracts with any of your investment providers or outside sources that you're using for any of your services. You're also going to want copies of the contracts, custodial agreements, group annuity contracts from any of your investment providers. And note that many of the 403B plans we deal with these days have upwards of 50 different investment providers in their programs. So this is a lot of information that you're going to have to gather and make sure you have all of this when they audit. The next thing is the universal eligibility compliance, which Bob went through what the rules were. You're going to be able to need to document that you have, in fact, done all of the notification that you've claimed that you do. So, for example, if you put information in the new hire packet as far as the program, if you've sent out emails, if you've had benefits fairs, if you do flyers, if you do presentations, all of that needs to be documented so that you can verify that you are, in fact, reaching out and notifying all of your employees that they're eligible, as well as when they can enroll. They talked about the 90-day period for enrolling and going through the process for if somebody wants to set up a salary deferral, how they do that as well.
Scott, let me ask you a question here, just to
Sure.
clarify for the audience as well. When you talk about the funds that you have available in the investment providers and documentation, you know, you and I worked in this for a while, and you know some plans will have all that right available, and others will say, okay, first step, my provider, help me find it, because I have no idea. I know I've twice come on plans where the first step for me was to locate all of the investment providers for a plan. How far back does this go? And what does it cover? How do you determine which things are actually going to be audited? Because as you know, with annuities, you may have an annuity that comes from 1979 that's still out there for 3 people, and you can't really track the information.
Sure, I can tell you, when we started back in 2009, when the regs first came into effect, we sent out communication to every investment provider we could find. Many times, if you're in a state like Texas or California that has a TRS-specific approved vendor list of all of the vendors that can be in the plan, it's a little bit easier. But basically sent out communication to all of them requesting, do you have assets for participants in any of these employers? And if they do have assets for any of those employers, they're to be included in the plan. And if they're not willing to sign the agreement, then you have to have documentation of the good faith effort that you've reached out to them and tried to incorporate them in the plan.
Thanks.
The other thing, keep going, financial records, that's really just the bank information as far as making sure you've sent the contributions via check, ACH wire, being able to reconcile so that you can verify the money that's been taken out of payroll has been contributed to the account. Contribution limitations, you're going to want to make sure you can produce the year-to-date contributions or MAC calculations for all of the employees. 15-year catch-up is going to be talked about by Kim because that is one of the big items you're running into with problems that employers are allowing the 15-year catch-up but not doing it properly. Ed can attest, we worked with a very large school district that allowed the 15-year catch-up and basically allowed employees to just self-certify that they qualify, which hopefully everyone in here knows that that's not how it works. So we would strongly encourage you don't allow it, but if you do, make sure you have the documentation that the employees you allow to use it do in fact qualify for it.
So I know we're running shorter on time, but any questions on this documentation, either in terms of how to go about getting it, what would be best practices for retaining it going forward, if you have questions about that? Question over on the right side of the room.
Just if we're going to be able to have access to this presentation afterwards.
Yes.
I have a comment. I hope you do have access to this presentation because as I'm looking at this and reviewing Scott's slides, this would be a perfect checklist for an employer to go through. Plan document, us. 1099s, the vendor. You know, just kind of a checklist to go through and communicate or ascertain where all this information is. So to, you know, proactive and be prepared. So I think it's a great tool. I want to use it.
Great.
Change our processes.
All right, an endorsement for all that we've done so far, so thanks.
And
Yep, next slide.
A couple more, employee census data. They will request date of birth, date of hire, termination date, job classification, salary, compensation, things like that. Generally going to be provided by the employer, so make sure you have that available as well. Enrollment or election forms, which may be a paper SRA. It also may be done online these days, so just documentation of how you have that. Copies of all the executive contracts or benefit packages for your, generally the ones I've seen is top 10 highest paid employees. They will ask for copies of all their agreements as well. Payroll files. There's also an internal control questionnaire that you will initially get with the IDR that you get up front, and they'll go through what is your process for new hires, what is your process for people that change job classifications, what are your procedures for people that are terminating and things like that that they'll go through.
We have a question on the right side of the room.
Oh, go ahead.
Thanks, Craig.
Oh, you jumped. I was getting to distributions. Just
Sure.
about there. So how does the IRS view substitute teachers? Because there's a little conflict especially between distributions and being able to defer. You know, when you have a substitute teacher who used to be an employee, they've terminated, now they want to take distributions, but they're working as a substitute on an ad hoc, as-needed basis. Does the IRS view that as an employee or as a contract worker or as a terminated person? How's the best to handle that?
Well, if they're a substitute teacher, then they are an active employee of the school district still. Now, you do run into issues where, if you're a substitute teacher, terminating employment, immediately getting a distribution because of severance of employment, and then the school district rehiring you 2 days later, that may be a little bit of an issue with the IRS should you be audited. But if they're an active employee, whether they're a substitute, they're considered an active employee.
Well, the harder part is sometimes they could go for a year without being called into work.
Correct.
You know, and so you have to carry them on your books as an employee if you might someday call them to come in and substitute. And during that time, they can't take a distribution. This is the problem we sometimes face with that definition.
Well, you know, I would just say, when you say they're an employee on the books, if they haven't worked for a year, they have no employee benefits, they're not participating in any other programs, I'm assuming? 125s?
They are retired generally.
Right. But that's what I'm saying. They're not, right, you're just talking about them coming in as substitute and they haven't been in. If they're working, they're going to show up. If they're not working, the IRS isn't going to pick it up or care because they haven't.
Well, does it matter if you're reporting your payment to them on a 1099 versus a W-2? Can you treat them as a contract employee on a 1099?
No. If they're your employee, they're going to go on the W-2. You're going to get yourself in trouble if you're not reporting them correctly. Put them on the W-2 if they're an employee. But go ahead.
I was going to say, for purposes of approving a distribution request,
Yeah.
we defer to the employer. If the employer considers them an active employee, they will not be eligible for distribution.
See, I guess
Different
from the
employers
employer's
do have-
perspective, the vendor says, okay, are they employed, are they not employed? And I'm like, well, they retired, but we might call them back to substitute. And so what do I?
Sure.
Okay.
Some employers we work with will have a time frame where if you don't work for 6 months or 180 days, they're termed. But that's up to the employer what the process is for terminating those.
But then if you change your mind and want them next week, then they're back again. Do they have to refile as a, hire on as a new employee? I guess maybe it's just way too loosey-goosey. You know, it's like they're substituting. You can call them in or you don't have to call them in, and it could be today and it could be next year. And you know, do you show them as an employee on your records or you don't show them as an employee on your records?
Generally, if they're eligible to be called in to be hired without filling out paperwork, I would consider them an employee.
Okay.
Thank you. We have another question in the other side of the room, please.
That's a plan document question. Is that going to be clarified in the plan document? I'm sorry, I'm just asking if that's a plan document question because my 457 plan document is employment, permanent separation is considered permanently separated with no intention of returning. So would that be clarified in the 403B document?
You'd always have to look at the document to see what, you know, have they severed under the document as you defined it, and are they an employee? But I mean, your document's going to say all common law employees, and you're smiling because there's no magic bullet that makes this work. In speaking as my former self and as an IRS auditor, you know, if that person hadn't been in there for a year, I'm probably not really concerned. They're coming in and out. Well, maybe they want to decide, and one of the times that they're gone, maybe they can get a distribution. If they're retired, are they 59 and a half, so you don't have to worry about it anyway.
Go ahead.
Would the fact that they might be taking a distribution from the pension plan and not making any pension contributions have any bearing on that whatsoever?
No, the 403B by itself, you got to look at the rules there. Whatever they're doing in the other plans, they stand on their own.
The question in the front. Thanks for the side, Scott. That's a pretty good one.
We're seeing a similar issue, but it's not substitute teachers. It's in a school system where employees are retiring, they want to take a distribution, they know that they're coming back in, let's say, 3 months' time, and they're going to be working 20 hours or less, something like that. We couldn't find any documentation on that either.
Are you talking about taking the distribution
Yes.
during the 3-month period
No.
while they are separated from
Yes.
service?
Yes.
Then that's fine. There's no requirement that if they're
You-
coming back
you
in the
agree
future,
from
that
the
would
IRS
prevent them from being
perspective?
eligible for that.
Well, now, remember,
'Cause
this says
This is knowingly coming back.
former.
I know, I
Okay.
know.
Everything he says has an asterisk, so don't sue him.
Well, I didn't know, I didn't speak for the IRS. It's always Bob and our opinion when we were with the IRS. But
To me, it's that they know they're coming back, so I kind of look at them as still being an employee, even though they've severed for a couple of months.
is there an agreement?
Yes.
Oh,
It's
okay.
a new category of employment that's being developed. And they're ending one form, they're unemployed for a short period of time, then they're coming back in another category.
But there's a signed agreement saying that you're still an employee and you're coming back at this date?
No, there's not, but they know that they're doing that, and the employer is looking for guidance on this.
Would you have a termination date for them in your system? Then generally speaking,
Yes.
from an audit standpoint, for the distribution verification, they're just going to request termination dates. And if you have a termination date, they're going to consider that eligible.
Okay.
Keep
Okay.
in mind, I will say this, what they will request is your dates of hire, dates of rehire, so those things will show up,
Correct.
yeah.
But if the distribution was taken post-termination date, pre-rehire date,
Then
there will not
nobody
be an
would
issue.
question that. As long as you don't have any written agreement that this is what we're going to do, you're guaranteed to come back.
Yes,
Just watch out for systematic distributions.
true.
It better be a one-time while they're separated. Sure, but if they're,
That's okay.
if anybody elects for a monthly systematic distribution, they come back under employment, though.
Yeah.
It'll be an operational problem.
Yeah, actually,
Good point.
not that I'm going to testify to its compliance, or how good an idea it is, but there are actually a number of institutions that are state higher ed institutions where they have limited in the past withdrawals or loans and other things like that. And so I had a client that was in that circumstance, and during the financial crisis, people for their homes and such, they would quit their job, take distributions, and then they would come back and be rehired on kind of the expectation they would get their job back. But it was one of the only ways they could access that, and that actually happened for a very large percentage of the planned population, where there was kind of the wink that was going to happen. The wink is the worry. Don't write the wink down, I think is the answer.
But as Kim's going to talk about here on the focus of the IRS and the problems that we see and that the IRS is really harping on, distributions for substitute teachers or employees that are going to be rehired is pretty low on the list of things you're going to get flagged for or penalized for.
So should we move on?
Yeah, you can move on. The last slide, distributions, is just generic there because the next slide is going to break it into basically loans and hardships, which is the biggest problem with distributions. You need to make sure loans, obviously, they're not borrowing more than 50% of their account balance or greater than $50,000 in aggregate. They'll want issues like loan amounts, the interest rate, the terms, the list of defaulted loans. Generally speaking, you're going to have to get all of that from your investment provider and make sure that your investment provider has that and can provide that to you, along with a list of who has defaulted on their loans and how those are being handled as well, which will also generally come from the investment provider. And then on a loan, if you're doing a primary residence loan, if the repayment term is longer than 5 years, documentation that the person did in fact purchase a primary residence. Yes, ma'am.
What kind of documentation have you seen that people can
For the purchase of primary residence, generally a closing statement or a good faith estimate or contract on the house. And then hardships is probably the most common problem that I see. First and foremost, I would recommend the employer try not to sign off on these if you have a plan administrator, because you will run into, like Ben was talking about, people coming into the office with a sob story, for lack of a better term, that, they said if you sign this, I can get my money. And people tend to buy into that and sign off on it and don't realize that the things you have as a problem are not considered a financial hardship under the plan document and under the IRS regulations. So it's best to have a third party not standing in front of that person, listening to their story, sign off and approve these, because many times we'll have school districts or cities sign off on requests that, you know, their car broke down or their cell phone got cut off, or things that are nowhere near a financial hardship distribution under the regs.
And I think it's probably important as well just to address the kind of what comes up as problematic and what comes up from an architectural perspective with respect to hardships and loan approvals in a multi-vendor scenario. If you wouldn't mind going into that just a little bit.
Sure. We sign off and approve all distribution requests for all of our clients, so we require physical copy of the documentation. So if it's a prevention of eviction or foreclosure, the notice from your lender that you're being evicted or foreclosed upon. If you're purchasing a primary residence, medical expenses will require an EOB from your insurance company showing your out-of-pocket expenses, or, you know, your bill or invoice from the medical provider. Tuition expenses, you'll need something, a tuition bill from a university showing what the cost of tuition is. So make sure you have that documentation, because you cannot accept an employee self-certifying, I have a hardship and need my money, let me get it out there. That will not pass.
And with respect to the limits in a multi-vendor scenario.
Go ahead with a question.
Where's the liability for bad distribution? We have this problem where we sent it to our deputy attorney general to set our providers were going to sign off on the hardship, but yet we were still responsible as the administrator at our level for that. So we still do it internally and do not send it to our providers because they wouldn't sign an indemnification basically that said we're not liable.
The employer is ultimately responsible for the plan and making sure the distributions are approved. Now, as a third party, we would hold the employer harmless to the extent that we could if we sign off and approve a hardship they request that's not legitimate. But most of these are pretty black and white. It's very rare that you get a gray area distribution. The problem is it's just usually somebody who really wants access to their money, has no other way to get it, and somebody feels bad and signs off and approves a request that they know doesn't qualify.
Other questions?
What's the appropriate length of time for record retention for this type of documentation?
3 years is generally the standard. We keep all of our documentation, I believe it's 6 or 7 years, but 3 years is generally the basic requirement.
And actually, if I could just expand on that, the IRS on their website suggests that you keep documents until the plan is entirely distributed. So that's obviously more than 3 years, but you should focus on knowing where 3 years worth of documentation is.
So 3 years is the standard, although the recommendation is greater than that. Is that the appropriate way to say that?
Yes.
You have 3 years, 3 open tax years, so you are susceptible to an audit for those 3 years. So you should know where those 3 years of documentation are. But this is a plan. The IRS can go back at any time. So the IRS is recommending via their website that you keep documentation for until the plan is, exactly.
And if they're auditing for 2010, let's say, and they find an issue, they're generally going to say, well, let's see the documentation for 2009 or 2008 to see if it's
You can expand.
It's always been a problem, or if it was unique to something that happened in that period.
Is it practical to keep documentation for 20 years, 30 years? No, but that's what's suggested on the website.
And be aware that when you have multiple vendors or you change vendors as well, different vendors will have different documentation retention policies in which some of them are required to remove documents after a certain period of time. They don't want the liability of having to go back from a cost perspective or a legal perspective beyond a certain point. So if you have your own internal document retention policies, try to give a look. They may not have actually been looked at to see how they match up if you have a legacy relationship, particularly if you're working in like K through 12 or higher where some of those have been in for a long time and haven't been examined. Those document retention policies should hopefully line up in a way that you're comfortable with and that would support any audit activity as well.
You had a question about multi-vendor in relation to hardships or in relation to?
With respect to approval, just insofar as, I mean, among other things, it effectively argues for some of the services that you provide, i.e. being able to look at the balances and transactions across multiple providers because of total limits due to the fact that self-certification is no longer permitted.
Correct. We basically, as a TPA require that they don't, an investment provider doesn't process a distribution unless we have signed off and approved the request. So we would look across all of the account balances to make sure they're not trying to get a hardship for the same expense out of multiple plans, which is probably the common.
So it sounds like
situation.
centralized administration really is important in a multi-vendor environment.
Correct. And the same would apply to loans as well. If a participant has multiple 403B accounts with different vendors, that 50,000 aggregate limit, or the 50% of their account balance, counts against that. You can't get a loan for $30,000 from two different providers there, so you got to make sure you aggregate that.
And which is to say that if you as plan sponsors are having that approval process, and you're looking in a silo and you can't adequately track across, you're exposing yourself. All right, so.
And then just one point on the last one on the hardships is you have to suspend contributions for 6 months. So make sure you have a mechanism in place that deductions are stopped for 6 months upon approval of the hardship. And then the last is just basically documentation of the 59.5, separation of service, and all the other distribution types that are available, making sure you have access to those records as well. And then I will pass it on to
All right.
Ben, how much time do we have?
We have about 15 minutes.
Okay, I'm going to modify.
Sorry about that.
No problem. I just want to give you some background about myself, just to let you know why I'm here. I do work for a vendor. I work in their compliance area, and part of my role is to fulfill the information document request on behalf of the sponsor. So I would be contacted by a sponsor, me personally, or my coworker. They'd send us the IDR, we'd look at it, review it, QA it, fulfill it, and get it out. So I do have experience with respect to helping sponsors fulfill that request. So I just want to give you that background before I move on. It shouldn't be any surprise to anyone that there's an uptick of IRS audits, specifically focusing on the 2010 plan year. Presumably, the 2010 plan year probably represents an adequate barometer in terms of how well the plan sponsor was able to implement the final 403B regs. So in other words, a plan sponsor has had an entire year of 2009 to try to work out the kinks to the best of their ability. I think in the past, we were perhaps notified maybe by 4 sponsors prior to the final regs. 4 sponsors a year, their plan is under audit, they send out the IDR to us and we fulfill it. Now, our log indicates 32 sponsors. In less than a year, we've been notified by 32 of our sponsors that their plans are under audit. And it's not just their 403B plan, it's their 457B plan as well. So just to give you some background there. In terms of audit selection, Ed tells me it's random. I don't know if that's the case. To reiterate what he indicated earlier, the not responding to the EPCU questionnaire, and also referrals from other agencies or other IRS audit functions. Let me see here. I was going to review in detail the audit process, but instead I will refer you to a concisely presented 2-page brochure which you can find on the IRS website. It's entitled Understanding the Employee Plans Examination Process. If you just do a Google search, you'll be able to find it. Can we move to the next slide, please?
Annual process overview.
There we go. Thank you. And basically, this outlines what the process is. You'll be contacted via phone or letter or both to initiate the process. There will be an initial interview with the IRS auditor. They'll ask for the plan document. They will want to discuss how you administer your plans. They'll be very much interested in your internal procedures. Do you have practices and procedures in place, internal controls, to help facilitate plan compliance? This is, I think, a very important interview because it's at this juncture that the IRS auditor may decide to go with a focused examination rather than a full scope comprehensive examination. And in a focused audit, they're only going to focus on 3 to 5 issues. And I imagine that their contributions, distributions, hardships, and likely eligibility, since that's one of the top compliance issues. If there is a lack of internal controls or procedures, or you can't adequately explain how you operate your plan, then it's possible that it will just be a full scope, comprehensive audit. So this is an opportunity to impress the auditor and perhaps reduce the length of the audit. In terms of the length, there are several factors that can impact the audit, and clearly one is the size of the plan. A plan with 100 participants obviously isn't going to take as much time as a plan with 2,100 participants. Also, as I indicated, the assessment of one's internal controls can reduce the size of the term of the audit. In addition to that, it's also, to the extent they discover problems, issues, the more issues that are discovered, that is going to extend the length of the audit. Just to give you some real-life example, we have a higher education public school that came under audit. We were notified in November of 2009 that the IRS was auditing their plan 403B and 457 for the 2007 and the 2008 plan years. That was in November 2009. In February 2012, we received a letter from the employer instructing us to make corrective distributions in an attempt to bring the plan back into compliance. So that time period is almost 2.5 years. And this plan is a big plan. I'm sure they have more than 25 participants. I don't know, Ed, if you can share any of your...
Yeah, I was going to say,
length.
you know, what makes an audit drag out? If you are not organized well enough so that, you know, they issue that IDR, 30-day turnaround. Okay, you start having, you know, you don't have your information readily available, or you never tried to get it before, you haven't looked, as Scott was talking about, you know, taking that list, or maybe it was Kim, and saying, okay, do I have these things? If it takes 90 days for you to obtain that information, then the IRS has to review. You just keep extending that length of time. And maybe there was going to be a 3 or 5 focused item. The IRS has come to your place of business. The information isn't ready. They're not going to sit there idle. They're going to, now that 3 or 5, you know, idle hands are not good. They're going to choose, well, while I'm waiting on this, maybe I ought to take a look at this, and you're going to get some more IDRs. So the quicker you respond, the less problem you will have from your audits.
Also, I want to put out one trend is, Kim talked about with the uptick of audits, is not all of the IRS examiners are nearly as experienced as Ed or Bob. So you will get an IRS agent, and I can tell you anecdotally, I had one that told me this is my second 403B audit, and the first one was an ERISA plan. You will get questions where they're asking for things that they should not be asking you for because it does not apply to your plan. So it helps if you know the rules and the regulations and what you're supposed to provide and how you're doing this, because you may get something that isn't applicable to your plan in a request.
In terms of the audit trends, I read something about giving out information to the participants about, for example, the fees that you charge for example, that line. Have you seen any effects along those lines?
Yes, well, obviously on the 401k sector, there's the new fee disclosure rules where you have to disclose all of this from a legal standpoint. In the 403B, there are attempts by the investment providers and the associations to try to make it more transparent, but depending on the investment provider, it may or may not be. For the most part, we disclose our fees on the summary plan description, and for the administrators, it's usually a pretty straightforward fixed dollar fee per month per participant. But there's an attempt, but it's still not always there.
Let me add that that comes in from the Department of Labor side for those organizations covered by ERISA. Others are perhaps doing it voluntarily, but from the actual compliance standpoint, that probably would not apply to anyone at NAGDCA.
But you may receive, the investment providers, some of them do send out the 408 disclosures, even for the 403B plans. So you may, as a plan sponsor, get a fee disclosure, even though it's not required by them to provide to you.
All right, so, yeah, please.
I'd like to ask a big question. The three of us are from North Carolina, and state director, deputy director, and I'm a trustee. The three of us are from North Carolina, state director, deputy director, and trustee. We're opening, in the process of opening a 403B program for everybody in our state. Could you, and with me as a trustee, could you tell me what the worst possible scenario would be for us to make this system work if we are as successful as I think we will be in pulling all these school district individual plans up to the state level? What should we prepare ourselves for? And has it been done elsewhere?
From personal experience, I can say yes, something similar has been done elsewhere. The state of California, CalSTRS, has a product that they're tied into an investment provider that they offer. Really, as an investment provider, you should be able to provide all of the documentation, all of the items we've talked about as far as loans, hardships, payroll files, contribution. I mean, really, you should be able to provide that data to the sponsor or to the administrator.
What I'm thinking about is all these smaller plans that we would be picking up if they have had problems. Well, all their problems come to our level for fiduciary responsibility and liability at the IRS level. Or do we get a clean slate from?
Well, now, fiduciary is not at the IRS level.
Okay.
That's your state statutes.
I can't think off the top of my head of a specific problem that you would inherit. I'm not aware of anything that would cause from a startup.
I can help out. In Delaware, we had that where we took over responsibility. We have 130 different legacy, and we just had to make sure we had a letter. I think to your point earlier, we had to make the best effort to contact every one of our legacy providers to say it's your responsibility to stay in track of the information and get it to us. And that's at the minimum level. If we can do more, we will. We have 13 providers right now, and it's a monster. I'm not going to say it is a monster to deal with, but we deal with it. But we had to make our best efforts to do that and show that we're trying to make an effort to contact all of them. So it's not easy.
Are you the employer?
I'm the plan administrator. State of Delaware is the employer. I'm the plan administrator, yeah.
So we're not the employer. We're actually the sponsoring organization.
Mm-hmm.
They don't actually report this, which I think makes sense.
Okay.
But I'm going to each other.
Sure.
You are not the administrator either. You're just the investment provider in the plan, correct?
We are a sponsor. We went out to bid, hired a firm, and created a state-sponsored program that we're going to make available to all the 115 school districts. But they're the individual plan, they continue to be the plan sponsor, the employer. We won't, our intentions right now are to not do an annual audit of the North Carolina-sponsored 403B program.
If a school district selected your program, who would be doing the administration function?
We'll have TIACREF as the investment provider, and then they can actually maintain their existing administrator or hire one of the pre-approved administrators by TIACREF.
Okay. There's not any problems I'm aware of that you would pick up from previous problems that I can think of, unless anybody else can think of any items.
Well, since 413C doesn't actually apply to 403B, that's the multiple employer environment. It's untested water for if one of them has something. These are all going to be individual employers throughout the whole product. You're just a sponsoring. So I don't, like I said, we never really tested the water, but I don't think one employer would bring down the product if they had a problem.
So Let's see if we can give some time just to, we're running a little bit, we might run a couple minutes past, but I want to give another 3-4 minutes if we could, just to let Kim wrap up. And we can, some of us will stick around as well for questions after.
Okay, I'm just going to touch upon a few of the audit trends. Excess deferrals, that's always an issue. And many times it's just simply, you know, a lack of adequate tracking in the payroll process, or not centralizing the monitoring. The 15-year catch-up is always an issue. So much so that I now suggest to clients that they take it out, particularly in light of the age 50 catch-ups that is currently available. But areas or potential pitfalls that include, would include, you need 15 years of service. They need to be full-time years. So someone that's been there for 20 years at halftime would not be eligible for the catch-up, but clearly someone working 30 years at halftime would be eligible for the catch-up. Some clients aren't aware that there's a $15,000 lifetime. You have to track that. No one really adequately tracks that, and you end up using the catch-up for a lot longer or at a higher dollar amount. Also, poor tracking with respect to prior contributions, prior employee contributions, because this is a calculation. You're required to, it's a 3-pronged calculation, and one of those segments is $5,000 times years of service minus prior elective contributions. So many times there's just not an adequate tracking of prior contributions, particularly in a multi-vendor situation where each vendor tracks their contributions, but to get them together to do an adequate calculation is challenging. And again, I have to reiterate, it is a calculation. It's not automatic. Universal availability, I won't go into that since we've addressed that. 5-year post-severance contributions here, they're inadvertently structured as elected deferrals rather than what they're supposed to be, which is employer contributions. In other words, upon a review of these contributions, it would appear that the employee had an opportunity or a choice to take the monies in cash or have it contributed to a 403B program. So again, they're supposed to be contributions, not employee elective contributions. So that's an issue. One of the big issues, I think, is lack of employer-vendor coordination, particularly in a multi-vendor environment. And this can negatively impact loans. It can create excess deferrals. It can impact hardship distributions, where you're receiving hardship distributions from multiple vendors for a single hardship event. And as Scott indicated, also, if you have a situation where the vendor authorizes and distributes hardships based on the safe harbor method, how is that vendor communicating to the plan sponsor that they need to suspend payments for 6 months? Lack of documentation, poor record retention, missing source documents in support of loans and hardships. And a recent issue that we had with respect to an IRS audit, we had a outstanding loan. It came up for the plan year, and it was a principal residence loan. It was taken 15 years ago. The IRS auditor asked us for our documentation, and we could not provide it. So that's not an uncommon scenario. And of course, last is form and operation. They just don't match. And some examples there would be the safe harbor hardship distribution that I just mentioned. The form, the document says you must suspend for 6 months, but you're not. Another example, the document states that you're only required 1 outstanding loan, but you find participants with multiple outstanding loans. Maybe the plan doesn't provide for plan-to-plan transfers in or out, yet you're allowing these transactions and not generating the appropriate tax reporting. So those are just some examples of form versus operation. And then we tried to put together a little survival kit for you, and there's nothing extraordinary here. It's simple, common sense. Initially, you should, if you come under audit, you should appoint a primary contact. It can be the plan administrator, the head of human resources, but certainly someone that's knowledgeable with respect to the plan and how it operates. And this person or individual serves as a point person with the IRS, and they really serve as a project, I would call them a project manager, where they're marshaling resources and organizing the effort on behalf of the employer. Also, I reiterate, put personnel on notice. Anybody who can provide information, adds value to this process, has knowledge regarding the administration of the plan or information impacting the plan should be put on notice. And, you know, that's vendors, TPAs, service providers, your upper management, the payroll department, the human resources department, anybody that you think could add value, you should put them on notice. Also be cognizant of timelines. As Scott suggested, if you need more time, ask for it, but do act upon it. Information that you're required to obtain should be gathered, reviewed, and organized. And I would strongly suggest a quality assurance review. One of the things I do when we're getting ready to package information off to the employer, I look for potential issues. I look for areas that we can be vulnerable and where the employer could be vulnerable, because that'll give you an opportunity to anticipate what the auditor will find and, you know, provide an explanation. And in addition to that, lastly, be prepared to adequately explain the operation of your plan and what internal controls you have in place. So that's our set of 5 guidelines to assist you. And that's it.
All right. Well, with that, we'd like to thank you all for attending, and we really appreciate it. There is a little note for review. We hope you have opportunity for it, to fill it out for NAGDA. They always find it very helpful. And for those of you who want, if you thank today's panel, we'd really appreciate it. I think we did a great job in giving you something, but I'll stick around. Some of us may stick around as well, and answer questions afterwards as time permits. Sorry that we ran out of time. So thank you, everyone.
Thank you.